SwayamPrabha. Digital India. Educated India.
Namaskar viewers and welcome to Swayam Prabha. I am Dr. Vageshwari Deswal, a professor at Faculty of Law, University of Delhi. I and Dr. Saurabh Rana, my colleague from University of Delhi, are delivering this course on Procedural Law on Crimes, Bharatiya Nagarik Suraksha Sanhita 2023. Today, in the 13th session of this course, I will be dealing with the topic charge. So, let us first try and understand what is a charge. The code does not define what a charge is. It is the precise formulation of the specific accusation that is made against a person who is entitled to know its nature at the earliest stage. So, this is how we interpret the term charge, because we do not have any statutory definition in this regard. There was a leading judgment on this, Ishar Singh versus State of AP. This is a 2004 judgment by the Supreme Court, in which the court said, a charge is not an accusation made or information given in abstract, but an accusation made against a person in respect of an act committed or omitted in violation of penal law, forbidding or commanding it. In other words, it is an accusation made against a person in respect of an offence alleged to have been committed by him. A charge is formulated after inquiry, as distinguished from the popular meaning of the word as implying inculpation of a person for an alleged offence. Another landmark judgment in this regard is V.C. Shukla versus State through CBI 1980 judgment given by the Supreme Court, in which the court said that the purpose of framing a charge is to give intimation to the accused of clear, unambiguous and precise notice of the nature of accusation that the accused is called upon to meet in the course of a trial. Chapter 18, consisting of sections 234 to section 247 under the BNSS, deals with the charge. First, we will talk about form of charge, which is given under section 234 to section 240. Section 234, contents of charge. The law says, every charge under the Sanhita shall state the offence with which the accused is charged. If the law which creates the offence gives it any specific name, the offence may be described in the charge by that name only. If the law which creates the offence does not give it any specific name, so much of the definition of the offence must be stated as to give the accused notice of the matter with which he is charged. The law and section of the law against which the offence is said to have been committed shall be mentioned in the charge. The fact that the charge is made is equivalent to a statement that every legal condition required by law to constitute the offence charged was fulfilled in the present case. The charge shall be written in the language of the court. If the accused, having been previously convicted of any offence, is liable by reason of such previous conviction to enhanced punishment or to punishment of a different kind for a subsequent offence, and it is intended to prove such previous conviction for the purpose of affecting the punishment which the court may think fit to award for the subsequent offence, the fact, date and place of the previous conviction shall be stated in the charge, and if such statement has been omitted, the court may add it at any time before sentence is passed. Illustrations. A is charged with the murder of B. This is equivalent to a statement that A's act fell within the definition of murder given in sections 100 and 101 of the Bharatiya Nyaya Sanhita, that it did not fall within any of the general exceptions of the said Sanhita, that it did not fall within any of the 5 exceptions to section 101 thereof, or that it did fall within exception 1 or the other of the 3 provisos to that exception applied to it. So, see, there is a clear difference between charge of murder and other charges. So, if it is not specifically mentioned that the person is being charged of murder, how does he know that he is being charged with murder or culpable homicide or causing death by a rash and negligent act? See, every killing is not necessarily murder. So, when the charge expressly states that this is a charge of murder, what this implies is that the act of the accused falls within the definition of murder. It is not covered any of the general exceptions of the Bharatiya Nyaya Sanhita. It is not covered under any of the exceptions also that have been appended to the charge of murder. So, this means that it is culpable homicide amounting to murder and it is not culpable homicide not amounting to murder. So, when it is written murder, so it is a clear cut indications that it is the highest degree of culpable homicide with which the accused is being charged and would be subjected to trial. Illustration B. A is charged under subsection 2 of section 118 of the Bharatiya Nyaya Sanhita with voluntarily causing grievous hurt to B by means of an instrument of shooting. Now, this is equivalent to a statement that the case was not provided for by subsection 2 of section 122 of the said Sanhita and that general exceptions did not apply to it. Then C. A is accused of murder, cheating, theft, extortion or criminal intimidation or using a false property mark. The charge may state that A committed murder or cheating or theft or extortion or criminal intimidation or that he used a false property mark without reference to the definitions of those crimes contained in the Bharatiya Nyaya Sanhita, but the sections under which the offence is punishable must in each instance be referred to in the charge. A is charged under section 219 of the Bharatiya Nyaya Sanhita with intentionally obstructing a sale of property offered for sale by the lawful authority of a public servant. So, the charge should be in those words. So, if there is a technical usage of terms, if the law has used some specific terms to denote any particular offence, those terms have to be necessarily used in the charge. See, what is the objective of the charge? That when an accused goes for trial, he should have a clear idea of what are the allegations against him. This is in order to enable him to prepare his defense properly. So, unless and until he has a fair idea of the accusations, allegations against him, till that time his defense would be compromised. So, that is why the law places great emphasis on the formulation of a charge in proper terms. Then section 235 deals with provisions regarding particulars as to the time, place and person. The law says, the charge shall contain such particulars as to the time and place of the alleged offence and the person, if any, against whom, or the thing, if any, in respect of which it was committed, as are reasonably sufficient to give the accused notice of the matter with which he is charged. Then when an accused is charged with criminal breach of trust or dishonest misappropriation of property or other movable property, it shall be sufficient to specify the gross sum, or as the case may be, describe the movable property in respect of which the offence is alleged to have been committed and the dates between which the offence is alleged to have been committed, without specifying particular items or exact dates, and the charge so framed shall be deemed to be a charge of one offence within the meaning of section 242, provided that the time intended or the time included between the first and last of such dates shall not exceed 1 year. See what would happen, suppose there is someone who is a habitual offender, someone who is like used to stealing. So the person has to know which particular instance of theft is he being tried for, and that is why we are insisting on specifying the time, the place, the person, everything. Section 236. When manner of committing offence must be stated. When the nature of the case is such that the particulars mentioned in sections 234 and 235 do not give the accused sufficient notice of the matter with which he is charged, the charge shall also contain such particulars of the matter, of the manner in which the alleged offence was committed, as will be sufficient for that purpose. See, we have certain illustrations. Illustration A. A is accused of the theft of a certain article at a certain time and place. The charge need not set out the manner in which the theft was effected. Then A is accused of cheating B at a given time and place. The charge must set out the manner in which A cheated B. See, what is the difference between illustration A and B? Illustration A is dealing with theft. See, what is theft? We have a clear definition of the same in Bharatiya Nyaya Sanhita. We also know the essential ingredients of theft, that there is a movable property, there must be a dishonest intention, the property should be moved in order to its taking away with such dishonest intention, there should not be the permission of the person in whose possession the property was. So, all that is specified when the term theft has been used in illustration A. But now, when we talk about illustration B, cheating. Now, cheating is definitely something which the law explains, but there are various modes in which cheating can be done. So, how was the person cheated? So, that has to be specified in the charge, only then the person would be clear as to what the accusation against him is. Then, illustration C. A is accused of giving false evidence at a given time and place. The charge must set out that portion of the evidence given by A which is alleged to be false. See, when there is an allegation of perjury, the person might have made many statements. Now, regarding which statement is he being accused of perjury? So, he needs to have a fair idea so that he can prepare his defense, and maybe he can prove his innocence. Maybe he can prove that he was under certain mistaken impression due to which he gave that statement, and he gave that statement on oath. So, all that has to be taken into mind while deciding whether any charge is complete in itself or not. Then illustration D. A is accused of giving false evidence at a given time and place. Now, this is done illustration C. Coming to illustration D. A is accused of obstructing B, a public servant, in the discharge of his public functions at a given time and place. The charge must set out the manner in which A obstructed B in the discharge of his functions. Illustration E. A is accused of the murder of B at a given time and place. The charge need not state the manner in which A murdered B, because murder in itself is clear that the person should have been killed, the person should have been killed by the person who is accused, and the accused should have done the act with the intention of causing death or intention of inflicting a bodily injury that is sufficient in the ordinary course of nature of to cause death, or with the intention which he knew would result in the death of that particular person, or with the knowledge that the act would definitely result in death, and despite having such knowledge the person did that act without any reasonable excuse for doing so. So, that in itself is clear when we use the term murder. Any further details might not be required. Then, A is accused of disobeying a direction of the law with intent to save B from punishment. The charge must set out the disobedience charged and what law has been infringed. So, a clear information has to be given to the accused person so that he can prepare his defense accordingly. Section 237, words in charge taken in sense of law under which offence is punishable. So, in every charge, words used in describing an offence shall be deemed to have been used in the sense attached to them respectively by the law under which such offence is punishable. So, you see what it says, what are the words that are used for describing an offence. So, when the law has defined any particular offence in any particular terms, like I just gave you the example of murder, like I gave you the example of theft. So, there already is a full-fledged definition in the Bharatiya Nyaya Sanhita which defines that offence with great precision. So, when the charge just mentions the title of that offence, that in itself is expected to give a fair idea of what he is supposed to prepare his defense against. So, when that specific expression which has been mentioned in the substantive law is mentioned in the charge, the accused can very well see what are the essential ingredients on the basis of which he can be penalized, and then accordingly he can prepare his defense. See, in criminal law what is required is that each and every essential ingredient of the accusation that needs to be proven. Burden of proof is throughout on the prosecution, and the prosecution has to discharge that burden beyond reasonable doubt. So, if there is any ingredient of that specific charge which the prosecution is not able to establish beyond reasonable doubt, then the benefit of doubt it goes to the accused person. That is why there is so much of emphasis on a clear formulation of the charge. And if there is any particular specified term for the offence with which the accused has been charged, the accused needs to be told that, so that he or his lawyer can refer to the main law so that they have a clear idea of all the allegations, of all the ingredients that the prosecution will try to establish against him, and accordingly he can prepare his defense. Section 238. See, what would be the effect of errors in formulation of a charge? The law says no error in stating either the offence or the particulars required to be stated in the charge, and no omission to state the offence or those particulars shall be regarded at any stage of the case as material, unless the accused was in fact misled by such error or omission and it has occasioned a failure of justice. So, what are the essentials of section 238C? No error. So, here first there has to be either some sort of an error, and the error should be in stating either the offence or the particulars required to be stated in the charge, and no omission to state the offence or those particulars, it shall be regarded at any stage of the case as material, unless what happened due to such error or what happened due to such omission, that the accused was misled by such error. due to which the accused could not prepare his defense properly. And that was the reason that it has led to a failure of justice. And that is the reason that the accused has been convicted. Had he known what the exact accusation against him or the exact charge was against him, so he would have prepared his defense to meet those accusations. But since there was an error in stating the offence, since there was a significant omission due to which he was not able to know that what was the charge against him. Suppose the accused was to be tried for the charge of murder, but the charge omitted this term murder. It said culpable homicide. Had it been written culpable homicide amounting to murder, then the accused would have got a fair idea. But now, because it omitted the term murder, the accused did not have a clear idea. See illustrations. A is charged under section 180 of the Bharatiya Nyaya Sanhita with having been in possession of counterfeit coin, having known at the time when he became possessed thereof that such coin was counterfeit. The word fraudulently being omitted in the charge. Unless it appears that A was in fact misled by this commission, the error shall not be regarded as material. Then A is charged with cheating B, and the manner in which he cheated B is not set out in the charge or is set out incorrectly. A defends himself, calls witnesses and gives his own account of the transaction. The court may infer from this that the omission to set out the manner of the cheating is not material. See, it would depend upon the facts and circumstances of each and every case. And who would be the judge in such case? The trying judge. He would have to see whether the accused has in fact been at a disprivileged position or he has suffered some sort of a loss owing to that omission or error in stating the charges appropriately. So now, what would be the effect of errors further? Illustration C. A is charged with cheating B, and the manner in which he cheated B is not set out in the charge. There were many transactions between A and B, and A had no means of knowing to which of them the charge referred and offered no defense. So, you see in this illustrations, he was misled because the charge did not specifically mention as to which exact incident of cheating was he being tried for. So, he could not prepare his defense for that particular incident. That is why he did not offer a defense in respect of the particular charge which he was not communicated properly owing to the error or omission in that charge. Now, the court may infer from such facts that the omission to set out the manner of the cheating was in this case a material error. So, you see, depending on the facts, omission of to state any specific terms, state any specific section, that could amount to a material omission. Then illustration D. A is charged with the murder of Khoda Baksh on 21st January. In fact, the murdered person's name was Haider Baksh and the date of murder was 20th January. A was never charged with the murder but one and had heard the inquiry before the magistrate, which referred exclusively to the case of Haider Baksh. The court may infer from these facts that A was not misled and the error in the charge was immaterial. But then look at the next illustration. A was charged with murdering Haider Baksh on 20th January 2023 and Khoda Baksh, who tried to arrest him for that murder on 21st January 2023. When charged for the murder of Haider Baksh, he was tried for the murder of Khoda Baksh. See, he murdered one person and then he murdered another person who tried to arrest him. Now, he has been charged for murdering Haider Baksh and Khoda Baksh. Both charges are there. The witness present in his defense were witnesses in the case of Haider Baksh. The court may infer from this that A was misled and the error was material. Okay? Because what happened, that he was charged for murder of Haider Baksh. He prepared his defense accordingly, he called for witnesses accordingly. But during trial, he was also charged for the murder of the other person whom he murdered when the other person was trying to arrest him. So, he might have had a defense that I killed this person in self-defense or maybe something else. But then till the time he was not told whose murder he was being tried for. He was told that he was being tried for the murder of A, whereas during the same trial, he was also tried for the murder of B. So, here this would be a significant omission in the framing of charges. The court may infer that A was misled and that is the reason why the error was material. There is a judgment, Stanley versus State of Madhya Pradesh. This is an old judgment, 1955 judgment, but the decision is very much relevant even today. See, what did the Supreme Court say? We see no reason for straining at the meaning of these plain and emphatic provisions unless ritual and form are to be regarded as of the essence in criminal trials. We are unable to find any magic or charm in the ritual of a charge. It is the substance of these provisions that count and not their outward form. To hold otherwise is only to provide avenues of escape for the guilty and afford no protection to the innocent. So, what is a charge? Precise formulation of an accusation. If the accused has a clear idea what he is being accused for, what particular offence at particular date, time, place, who was the actual victim, when he has all these informations, in case there is some insignificant error in maybe stating the section, whereas the title of the charge has been mentioned, then in such cases sometimes the courts may overlook that, because as you will see in this judgment, it is the substance of these provisions that count. It is not their outward form. If we were to insist on each and everything, what would happen? We would be providing avenues of escape for the guilty person, and at the same time we would not be protecting the innocent persons. See, in criminal trials, a balance has to be struck. No innocence should be, no one who is an innocent person should be condemned, and at the same time we have to ensure that the guilty should not be able to take advantage of any lacunas in the law, utilize those lacunas for his defense and try to evade punishment under the law. So, we do not have to focus on the outwardly form. What we need to focus on is the substance. See, this is a judgment which holds good even today. The provisions relating to charge, they are the same as they were in the previous code. The Bharatiya Nagarik Suraksha Sanhita did not have to change them, because the provisions regarding to formulation of charge have been formulated very nicely. See, anyway, the CRPC 1973 was enacted by us to keep in mind the constitutional goals. See, the constitutional goal is to punish the accused person, but without compromising on the rights of an accused person. See, just because a person is accused, just because there is an allegation against a person, that does not mean that his rights would evade him. He is an accused, but would become a convict only when he is tried by a court of competent jurisdiction and that court adjudges him guilty. It is only then that the person can be punished. Before that time, we have to proceed on the presumption of innocence, and all constitutional protections and guarantees are to be given to him. Because see, when we look at the criminal justice system, on one side there is the police and the prosecution. They are all trying to prove the accused person guilty. On the other hand, there is this accused person trying to defend himself against the system. So, any system that does not take into account the constitutional rights of an accused person cannot be a good system. And that is why in 1973, when we reenacted our procedural criminal law, those constitutional provisions were taken care of. But then again, over the years, it was realized that the law needed to be amended to keep in tune with the changing times. There were also certain international conventions that we had signed, and accordingly we had guaranteed certain rights to the accused persons, certain rights to the victims. We also needed new kinds of procedure to deal with new crimes that had cropped up due to evolving technology. There were newer forms how accused persons, they were trying to cover up their footprints of crimes. So, how do we ascertain that a crime has been committed? All this necessitated the overhauling of the old law and drafting of the new Bharatiya Nagarik Suraksha Sanhita. But when we come to provisions of charge, the old provisions, they hold good. Now, let us talk about section 239, that is alteration of charge. How can the court alter charge? Section 239 says, any court may alter or add to any charge at any time before judgment is pronounced. Every such alteration or addition shall be read and explained to the accused. So, you see, even once when the charge sheet has been drawn up and the trial is proceeding, but judgment is yet to be pronounced and the court feels that some charges they need to be added or there needs to be some alteration in the charge, then what is the court supposed to do? The court is supposed to read out that charge. Not only read out that charge to the accused, also to explain that, see, these are the changes that are being brought about in the charges. So, why is this needed to be done? So that there should not be a lack of opportunity to the accused person to defend himself against the new charges that have been formulated against him, on the basis of which he might be punished. So, sometimes it might necessitate the reconducting of a trial also. So, you see, the precise formulation of accusation plus the communication to the accused person, these are so vital in any criminal trial, and here the responsibility has been put on the magistrate that he is supposed to tell the accused person that, see, this is the alteration or addition. He has to be told that, and it also needs to be explained what would be the consequences of such addition or alteration. If the alteration or addition to a charge is such that proceeding immediately with the trial is not likely, in the opinion of the court, to prejudice the accused in his defense or the prosecutor in the conduct of the case, the court may in its discretion, after such alteration or addition has been made, proceed with the trial as if the altered or added charge had been the original charge. So, you see, in subsection 3 of section 239, the law is talking about not only the accused person, but also the prosecution. See, a fair idea of the charge has to be there with the prosecution also, because they need to prove those charges. They need to accordingly prepare their side of the case so that all the essential ingredients of that new charge might also be established. So, what is important is not only the accused, but the prosecutor should also know, and in case it appears after giving the information to the prosecutor as well as to the defense side, that, see, there would be no disadvantage to either of the sides, then in such cases they may just proceed with the trial as if that charge was also a part of the original charge sheet. Then, if the alteration or addition is such that proceeding immediately with the trial is likely, in the opinion of the court, to prejudice the accused or the prosecutor. So, you see, if it appears that either of the side would be prejudiced, they are not well prepared, the prosecutor is not well prepared to establish that charge, or the defense is not adequately prepared to rebut that charge, then in such cases, the court may either direct a new trial or adjourn the trial for such period as may be necessary. In case they feel that there has to be a retrial, then it would be a de novo trial. But if they feel that no, maybe we can give some time to the prosecutor or the defense to prepare their case, then what would be done? The same trial would continue, but it would be adjourned for the time being, so that both the parties, they can accordingly prepare themselves and then present themselves for the trial armed with the new information or the new evidences or any new witnesses if they want to present in order to establish or negate the charge. But a fair opportunity needs to be given to both the prosecution as well as defense in case there is a new charge that needs some more time. Then, if the offence stated in the altered or added charge is one for the prosecution of which previous sanction is necessary, the case shall not be proceeded with until such sanction is obtained, or unless sanction has been already obtained for a prosecution on the same facts as those on which the altered or added charge is founded. See, there are certain categories of persons for whom before trying against them a sanction has to be obtained from the appropriate authority, which could be the state government or the central government. So, before obtaining that sanction, they have to be supplied with the exact information on which the accused would be tried. It is only then that the state or central government may give permission or may give sanction to prosecute that person. So, in case there is any alteration or addition in charge against such public servant or such person for whose prosecution a previous sanction is necessary, then it would have to be seen that whether the addition or alteration is affecting the trial substantially, whether the sanctioning authority had a fair information of what the charges would be against him, and accordingly it would be decided whether we have to wait for a new sanction or whether the trial can continue unabated. See, look at the judgments in this case. Thakur Shah versus Emperor, it's an old judgment in which the Privy Council observed that alteration or addition is always subject to limitation, that no course should be taken by reason of which the accused may be prejudiced, either because he is not fully aware of the charge made or is not given full opportunity of meeting it and putting forward any defense open to him on the charge finally preferred. So, this is a judgment which holds good even in the contemporary context. Then, in Rajbir, alias Raju and another versus State of Haryana 2011 Supreme Court judgment, the Supreme Court had directed all trial courts in India to add section 302 IPC in every case alleging commission of an offence of dowry death punishable under section 304B of the IPC, because the court strongly felt that heinous and barbaric crimes against women in the country need to be sternly dealt with. See, section 304B was introduced in the Indian Penal Code in the year 1986. Now, dowry death specifies what are the essential ingredients of dowry. What does it say? There has to be death of a woman, the death should be otherwise than under normal circumstances, the death should have taken place within 7 years of her marriage, and the prosecution also has to establish that soon before her death, the woman was subjected to cruelty or harassment by her husband or in-laws, and that such cruelty or harassment was in relation to demand for dowry. So, you see 304B in itself, it establishes what are the essential ingredients of the crime. And if it is that kind of a killing, then it would be called as dowry death. See, when it is already called as dowry death, what is the necessity to introduce section 302 in it? Because if death has been established and it is an intentional killing, or it is a killing with the knowledge that the death would be caused by this, then it could easily be covered under 302, because dowry death could be an aggravated form of murder. On the other hand, there is also a possibility that it was suicide, because see, dowry death is also sometimes referred to as constructive homicide. Homicide is killing of a human being by another human being, and constructive homicide, that is when the person was not actually killed by another person, but the other person created such circumstances due to which the victim was compelled to take away his or her own life. Then it is a case of constructive homicide or suicide, which would also be covered under dowry death. So when we got this judgment in 2011, it was that the judiciary was keen on dealing sternly with crimes against women, because despite having so many laws for such a long time, there has been an upsurge in the crimes against women. But further, it was clarified subsequently in Jaswinder Saini and others versus State that Rajbir case is not to be followed mechanically. See, what did the court mean? That when a charge alleging dowry death is framed, a charge under 302 can also be framed if the evidence otherwise permits. So you see, the same facts that have been utilized for the formulation of a charge under 304B, the same facts would stand good in order to frame a charge under 302. So if after the trial the judge feels that it is not only dowry death that the person should be punished, and if the court wants to alter or add to the charge subsequently section 302 also, it is not that the addition is necessitated by some subsequent discovery of facts during the trial which has necessitated such addition of charge. So on those very facts, the accused could be, then there could be a charge of 302 also, and on the same basis he could be punished also. So you see, Rajbir and another versus State of Haryana, that is not wrong, but the courts have just sounded a word of caution that we should not be mechanically applying the same. That is, we should not read just one line that, see, if 302 has not been mentioned, then the persons cannot be charged with murder. No, that would not be the thing. In the larger context, we have to see and understand this particular judgment. Let us talk about section 240. See, when charge is altered, does it permit us to recall the witnesses? See, some witnesses might already have been examined during the trial, and what would the impact of alteration of charges upon recalling the witnesses? The law says, whenever a charge is altered or added to by the court after the commencement of the trial, the prosecutor and the accused shall be allowed to recall or resummon and examine with reference to such alteration or addition any witness who may have been examined, unless the court, for reasons to be recorded in writing, considers that the prosecutor or the accused, as the case may be, desires to recall or re-examine such witness for the purpose of vexation or delay or for defeating the ends of justice. Also, to call any further witness whom the court may think to be material. So, unless and until it is being deliberately to delay the ends of justice, recall would not be permitted, but if it is required, then it can be done, and also further witnesses, not only the witnesses who were already examined, if required, any more witnesses also whom the court considers examining is necessary to arrive at the correct decision, even they can be called. Now let us talk about joinder of charges. Section 241 to section 247 of the BNSS deals with joinder of charges. Section 241 separate charges for distinct offences. For every distinct offence of which a person is accused, there shall be a separate charge, and every such charge shall be tried separately, provided that where the accused person by an application in writing so desires, and the magistrate is of opinion that such person is not likely to be prejudiced thereby, the magistrate may try together all or any number of the charges framed against such person. Nothing in subsection 1 shall affect the operation of provisions of section 242, 243, 44 and 246. Look at the illustrations. A is accused of a theft on one occasion and of causing grievous hurt on another occasion. A must be separately charged and separately tried for the theft and causing grievous hurt. See, if A was charged of causing simple hurt on one occasion and grievous hurt on another occasion, he could still have been tried together. But then here we are talking about two distinct offences. One is theft, another is grievous hurt. It is not necessary that theft has to be accompanied with hurt. Then in such cases, there have to be separate charges and separate trials also. Then offences of same kind within year may be charged together. Under section 242, when a person is accused of more offences than one of the same kind committed within the space of 12 months from the first to the last of such offences, whether in respect of the same person or not, he may be charged with and tried at one trial for any number of them not exceeding 5. Offences are of the same kind when they are punishable with the same amount of punishment under the same section of the BNS or of any special, provided that for the purposes of this section, an offence punishable under subsection 2 of section 303 of the BNS shall be deemed to be an offence of the same kind as an offence punishable under section 305 of the said Sanhita, and that an offence punishable under any section of the said Sanhita or of any special or local law shall be deemed to be an offence of the same kind as an attempt to commit such offence when such an attempt is an offence. Section 243, trial for more than one offence. If in one series of acts so connected together as to form the same transaction, more offences than one are committed by the same person, he may be charged with and tried at one trial for every such offence. What are the illustrations to subsection 1? A rescues B, a person in lawful custody, and in so doing causes grievous hurt to C, a constable in whose custody B was. A may be charged with and convicted of offences under subsection 2 of section 121 and section 263 of the BNS, because see, these series of acts, they were closely connected. Then A commits housebreaking by day with intent to commit rape and commits in the house so entered rape with B's wife. A may be separately charged with and convicted of offences under section 64 and subsection 3 of section 331 of the BNS, because housebreaking by day, rape, these are two distinct offences in which we need to establish different facts and different established intentions. Then A has in his possession several seals, knowing them to be counterfeit and intending to use them for the purpose of committing several forgeries punishable under section 337 of the BNS. A may be separately charged with and convicted of the possession of each seal under subsection 2 of section 341 of the Bharatiya Nyaya Sanhita. With intent to cause injury to B, A institutes a criminal proceeding against him, knowing that there is no just or lawful ground for such proceeding, and also falsely accuses B of having committed an offence, knowing that there is no just or lawful ground for such charge. A may be separately charged with and convicted of 2 offences under section 248 of the BNS. Then section 243, trial for more than one offence. What are the further illustrations to subsection 1? A, with intent to cause injury to B, falsely accuses him of having committed an offence knowing that there is no just or lawful ground for such charge. On the trial, A gives false evidence against B, intending thereby to cause B to be convicted of a capital offence. A may be separately charged with and convicted of offences under sections 230 and 248 of the BNS. A, with 6 others, commits the offences of rioting, grievous hurt and assaulting a public servant, endeavouring in the discharge of his duty as such to suppress the riot. A may be separately charged with and convicted of offences under subsection 2 of section 117, subsection 2 of section 191 and 195 of the BNS. A threatens B, C and D at the same time with injury to their persons with intent to cause alarm to them. A may be separately charged with and convicted of each of the 3 offences under subsections 2 and 3 of 351 of the BNS. The separate charges referred to in illustrations A to G respectively may be tried at the same time. See, when a person charged with one or more offences of criminal breach of trust or dishonest misappropriation of property as provided in subsection 2 of 235 or in subsection 1 of 242 is accused of committing for the purpose of facilitating or concealing the commission of that offence or those offences, one or more offences or falsification of accounts, he may be tried with and tried at one trial for every such offence. And if the acts alleged constitute an offence falling within 2 or more separate definitions of any law in force for the time being by which offences are defined or punished, the person accused of them may be charged with and tried at one trial for each of these offences. So, what are the illustrations to subsection 3? A wrongfully strikes B with a cane. A may be separately charged with and convicted of offences under subsection 2 of 115 and 131 of the BNS. Then several stolen sacks of corn are made over to A and B, who knew they are stolen property for the purpose of concealing them. A and B thereupon voluntarily assist each other to conceal the sacks at the bottom of a grain pit. A and B may be separately charged with and convicted of offences under subsections 2 and 5 of 317 of BNS. Then A exposes her child with the knowledge that she is thereby likely to cause its death. The child dies in consequence of such exposure. A may be separately charged with and convicted of offences under sections 93 and 105. A dishonestly uses a forged document as genuine document or genuine evidence in order to convict B, a public servant, of an offence under section 201 of the BNS. A may be separately charged with and convicted of offences under section 233 and subsection 2 of section 340 read with 337 of that Sanhita. 4. If several acts of which one or more than one would by itself or themselves constitute an offence constitute when combined a different offence, the person accused of them may be charged with and tried at one trial for the offence constituted by such acts when combined and for any offence constituted by any one or more of such acts. Now, what are the illustrations? A commits robbery on B and in doing so voluntarily causes hurt to him. A may be separately charged with and convicted of offences under subsection 2 of 115 and subsection 2 and 4 of section 309 of the BNS. And nothing contained in this section shall affect section 9 of the BNS. Now, what would happen when it is doubtful what offence has been committed? Under section 244, if a single act or series of facts is of such a nature that it is doubtful which of several offences the facts which can be proved will constitute, then the accused may be charged with having committed all or any of such offences, and any number of such charges may be tried at once, or he may be charged in the alternative with having committed some of the said offences. If in such a case, the accused is charged with one offence and it appears in evidence that he committed a different offence for which he might have been charged under the provisions of subsection 1, he may be convicted with of the offence which he is shown to have committed, although he was not charged with it. See illustration. A is accused of an act which may amount to theft or receiving stolen property or criminal breach of trust or cheating. He may be charged with theft, receiving stolen property, criminal breach of trust and cheating, or he may be charged with having committed theft or receiving stolen property or criminal breach of trust or cheating, either of these. Then in the case mentioned, A is only charged with theft. It appears that he committed the offence of criminal breach of trust or that of receiving stolen goods. He may be convicted of criminal breach of trust or of receiving stolen goods, as the case may be, though he was not charged with that offence. Then A states on oath before magistrate that he saw B hit C with a club. Before the sessions court, A states on oath that B never hit C. A may be charged in the alternative and convicted of intentionally giving false evidence, although it cannot be proved which of these contradictory statements was false. Then section 245 deals with when offence proved included in the offence charged. Section 246 also tells us what persons may be charged jointly. That is, those who are accused of same offence that are committed in the course of same transaction, or when persons are accused of an offence and those who are accused of abetment of or attempt to commit such offence. When persons are accused of more than one offence of same kind which is committed by them jointly within a period of 12 months, when persons are accused of different offences, but then those different offences are committed in the course of same transaction. So you see, all these persons, they can be tried jointly. Then under section 247, when a person is convicted of one or several charges, then the remaining charges can be withdrawn. Okay. So students, in this we try to understand in this particular session what is a charge, what are the ingredients of a charge, and what is the necessity for a precise formulation of a charge, that is to protect the interests of both the accused persons and also to guide the prosecution as to conduct the prosecution in a proper manner. So students, I hope you are clear with the provisions regarding charges. That will be all for this session. Thank you.